start. This was despite the fact that deceased was also working as a full-time lecturer in the local government college. Stop. It was further alleged that due to non-fulfillment of the dowry demands, the vicious cycle of humiliation and abuse continued to be meted out to the deceased. Stop. The deceased contacted the complainant on 30/9/2017 and informed that she had been again physically tortured because of her failure to meet their dowry demands. Stop. The complainant assured that he would try to amicably settle this household squabble by coming to her marital home on the very next day. Stop. However, this assurance could never be materialized as the accused are alleged to have clandestinely administered poison to the deceased on 1/10/2017, which led to her unfortunate demise the following morning. Stop. It is to be noted that the factum of poisoning is supported by medical evidence gathered by the investigating agency. Stop. Para. Soon after the FIR was lodged, the respondent accused moved an anticipatory bail application before the Sessions Court, which was rejected on 21/12/2017. Stop. Discontented, the respondent accused approached the High Court for a similar relief, but the petition was dismissed as withdrawn on 8/3/2018. Stop. Meanwhile, on account of non-cooperation with the ongoing investigation, the SHO of the concerned police station applied for and got issued arrest warrants against the respondent accused from judicial magistrate. Stop. However, the arrest warrant could not be executed as the respondent accused had been on the run and she was thus declared an absconder on 23/4/2018 under Section 82 of the Code of Criminal Procedure (for short CRPC). Stop. Para. The respondent accused continued to evade her arrest until this court granted anticipatory bail to her younger son Daksh Adya (brother-in-law of the deceased) on 22/10/2019. Stop. Thereafter, taking advantage of this subsequent event and presenting the same as a material change in circumstance, respondent accused filed 2 petitions before the High Court, seeking quashing of the order that declared her a proclaimed offender and further sought the relief of anticipatory bail. Stop. Para. It is noted explicitly that during the pendency of the above-mentioned proceedings, the High Court granted interim bail to the respondent accused on 3/12/2020 and pursuant thereto, she joined the investigation on 7/12/2020. Stop. Thereafter, while the impugned order, High Court allowed both the petitions and set aside the order declaring the respondent accused as an absconder and also granted her anticipatory bail. Stop. These reliefs were primarily allowed on 2 grounds. Firstly, that the respondent accused had joined the investigation and undertook to remain present at each date of trial proceedings. Secondly, she was entitled to seek parity with the co-accused Daksh Adya, whom this court granted anticipatory bail. Stop. Para. The aggrieved complainant is before us, contending inter alia, that the High Court has committed a grave error of law in overlooking the well-established principles which guide courts to exercise their discretion in the matter of granting anticipatory bail. Stop. Learned State Counsel has also supported the cause of appellant complainant stop at the outset, comma, it would be fruitful to recapitulate the well settled legal principle that the cancellation of bail is to be dealt on a different footing in comparison to a proceeding for grant of bail stop over.